That is a violation of the law. And the only thing that I can think of is that those same agreements with the music copyright owners indemnify YouTube. In other words, the DMCA is a safe harbor. Well, if they're going to give up their safe harbor, then the music copyright owners probably had to agree that they would pay for YouTube's damages if YouTube got sued and was found to not be in its safe harbor. This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. All right, so this happened, I guess it was yesterday. Adam Neely, who is at Adam Neely Base on May 4th, may the 4th be with you, writes, "Hey YouTube and YouTube creators and Warner Chappell, my counter notification for my single ladies analysis DMCA takedown was rejected. What documented evaluation was done on that video that ruled out fair use? Lens v. Universal," and he gives a citation and says that it requires this. And even Legal Eagle chimes in, "What is going on with the system? This is a new development. No one should be able to reject a DMCA counter notice." And then Adam goes on to say, wait, this is officially YouTube's policy to reject counter notifications in some cases. Let's see what they sent him. "Dear Adam Neely, thank you for your counter notification. Based on the information you provided, it appears that you do not have the necessary rights to post the content on YouTube. Therefore, we regretfully cannot honor your request. It has not been forwarded to the original claimant, and we will not be able to restore your video. To learn more about copyright, you may visit our Copyright Center." Well, if we go over here to 17 U.S.C. 512, which is the DMCA part about safe harbors, and we go down here to section G, which is about the replacement or removal of disabled material and limitation on other liability. This is the safe harbor provision. No liability for taking down for any claim based on the service provider's good faith, disabling of access to, removal of material or activity claimed to be infringing or based on facts or circumstances from which infringing activity is apparent, regardless of whether the material or activity is ultimately determined to be infringing. So no liability if you, in good faith, disable access, but paragraph 1, remember, paragraph 1 limits liability, so paragraph 1 does not limit your liability with respect to certain exceptions. Material residing at the direction of a subscriber of the service provider on a system or network controlled or operated by the service provider that is removed or to which access is disabled by the service provider pursuant to the notice provided in a takedown notice, unless the service provider takes reasonable steps to promptly notify the subscriber that it has removed or disabled access, and upon receipt of a counter notification, promptly provides the person who provided the notification, the takedown notification, with a copy of the counter notification, informs the person that it will replace the removed material, in other words, put the taken down material back up, and cease disabling access to it within 10 business days, and then replaces the removed material and ceases disabling access to it in not less than 10, not more than 14 business days following the receipt of the counter notice, unless its designated agent first receives notice from the person, original claimant, who submitted the notification that they've filed a lawsuit or otherwise obtained a court order. The contents of the counter notification are up here, and then we can go back up here to see the format of a takedown notice. So this is the safe harbor provision that is preventing Adam Neely from suing YouTube. So if YouTube is in violation of that, then YouTube can be sued for taking down Adam Neely's video. And that's what they go on to say here. It could be a 512G2B, which is what we just looked at, violation. Legal Ego says, bingo, this seems like a weird situation. I agree that this seems like a weird situation. And then Adam Neely points out this. Some videos removed or blocked due to YouTube's contractual obligations. YouTube enters into agreements with certain music copyright owners to allow use of their sound recordings and musical compositions. In exchange for this, some of these copyright owners require us to handle videos containing their sound recordings or musical works in ways that differ from the usual process on YouTube. I think they mean the law. Under these contracts, we may be required to remove specific videos from the site, block specific videos in certain territories, or prevent specific videos from being reinstated after a counter notification. In some instances, this may mean the Content ID appeals or counter notification process will not be available. Your account will not be penalized at this time. YouTube will inform you if this is the case for one of your videos and will provide you with contact information for the complainant whenever possible so you can discuss the matter directly. That is a violation of the law. And the only thing that I can think of is that those same agreements with the music copyright owners indemnify YouTube. In other words, the DMCA is a safe harbor. Well, if they're going to give up their safe harbor, then the music copyright owners probably had to agree that they would pay for YouTube's damages if YouTube got sued and was found to not be in its safe harbor. I recommend that people like Adam Neely or in Adam Neely's position that have received an illegitimate notice like this to contact a copyright attorney like myself, or I don't know if Legal takes cases, but there's a bunch of other good copyright attorneys out there and should be pursuing this violation of the DMCA 512G, accusing them of copyright infringement, accusing them of a contract violation, everything under the sun, because this is like was cited. This is illegal under Lentz v. Universal. The copyright owners have to conduct a fair use analysis before they take down your material. They can't just take down your material while completely disregarding fair use, or else they're liable for that takedown. So if you are affected by that, you can do something about it, but it's got to be done in court.
I have a strange jurisdiction question.
Yes.
So, assuming that the copyright holder and the YouTuber are both in the US, how would you determine which district you sue in? Would it be the state that the copyright holder is in, the state that the YouTuber is in, or the state that YouTube is incorporated in?
This is a separate topic of law called choice of law, I believe. Usually you have to sue under the jurisdiction for where the injury occurred. The law is pretty complicated. We're basically looking for the defendant to have a minimum contacts with the forum state. So if YouTube is the defendant, does YouTube have minimum contacts with California? Well, yeah, YouTube is in California. Well, YouTube also has offices in New York, so maybe you could also get to YouTube in New York. And YouTube does business in every state in the union, so maybe you could even make an argument that basically any place where you are and you're using YouTube, you could be injured. Many states, well, all the states, also have jurisdictional laws about if someone's injured, who can you reach? If someone out of state injures me in my state, can I sue them in my state? Do I have to go to their state? The state's long arm statute, literally the long arm of the law, the long arm statute determines when you're allowed to sue. So a lot of times federal jurisdiction will depend a little bit on where the injury was incurred, and you might, if I recall correctly, because I haven't had to file a complaint like this in a while, you look up the state's long arm statute to determine the basis for filing, where your proper venue and jurisdiction is. Basically, so yes, I know the state's long arm statute is the state statute, but what basically you're looking for something that follows the law of jurisdiction. Bell Atlantic v. Twombly, International Shoe v. Volkswagen, I think it was. And that is our show, everyone. Thank you very much for joining me, Leonard French, your favorite copyright attorney, for this Cinco de Mayo episode of Lawful Masses. This is a community-supported legal education channel. Thank you very much for your support on patreon.com/ljfrench and sponsus.org/u/lawfulmasses, as well as Twitch subscribers and YouTube join members, which will be turned on shortly here. Thank you very much to our May $50 plus supporters: John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Michael Pearce, Terry Crisp, Jan Negrey, Spirit Bear, Daniel Perez, Richard Fournier, Snorre Wisotzky, allquixotic, and Aspernari. Thank you very much for your support at the $50 level, and thank you to the $5 plus supporters who are scrolling on the LED panel behind me and will also be in the crawl and the description of the videos that drop. Once again, thank you for joining me. In the studio here, we've had Ms. Kaylee and Brandon and Tactical. Appreciate you all. And of course, we have a Nico here someplace if I can get him back. But otherwise, you guys have a great week. It's spring. I hope it's warm for all of you Northern Hemisphere persons. Come on, hup, boy, and we'll take out the stream. Hup, come on, go boy, go boy. All right, everyone. Love you all. I am Leonard French, your favorite copyright attorney, and I will see you this week in the videos that drop. Bye.